For reasons mentioned in the judgment, both the appeals are partly allowed. Though this court has not interfered with the assessment of market value of the acquired land as well as assessment of compensation computed against the Jirat. However, this court is of considered opinion that the compensation assessed against the damage caused to Zirat cannot be deducted from the compensation assessed against the market value of the land at the date of notification of under section 4 of the Act. Therefore, the impugned judgment and award of the reference court, to the extent of it deducting of the Jirat compensation already paid to the appellant from total compensation for the acquired land of the market value, is found contrary to the statutory provision and accordingly set aside to that extent. The appellants are therefore entitled to the amount which was deducted as Jirat compensation from the total compensation against market value of the acquired land, along with the interest thereon at the rate prescribed by the provisions of Land Acquisition Act.
May I please, your Lord? With the concept, my learned senior, item 25 of supplement, we have been engaged just now, madam. We are filing Galatama. So we may be kindly be accommodated, madam. My learned senior has consulted me. We have prayed for 2 weeks' time, but he will be out of station. So let it come Friday as per his desire.
Next Friday. Okay. Heard Mr. A.C. Sharma, learned senior counsel assisted by Mr. B. Devri. Also heard Mr. S.C. Bishwas, learned counsel for the respondent, who submits that they have been engaged in this case
Just now, madam.
today only,
Yes.
and therefore needs some accommodation so that he may go through the brief of the case. The counsels, learned senior counsel for the appellant, raised no objection to the prayer, and same is allowed. Let this matter be listed on 7th of November.
7th, sir.
7th of November.
Diploma. Sir, thank you.
Lordship, I beg to mention item number 15, with the consent of the other side. Lordship, we need some more time to file the application to convert the application to an RFA.
What application?
As the appeal is now under MFA, we need some time to convert it.
You want to file a interlocutor? Interlocutor.
Lordship,
Then
an application to convert the appeal into an RFA. Also, we have to give a court fee, so we need some time.
okay. Heard Miss S. What is your name? B. Chauhan. Item number 15.
Yes.
Learned counsel for the appellant, who seeks an adjournment for taking steps for converting the present MFA into RFA. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks. 4 weeks.
We have leadership. That's why I beg to mention for listing an MSc appeal.
Senior court, you have to For listing, there is a senior code. You have to mention before that code.
Praise the Lordship. Lordship, item number 23. Kindly pass on the matter for the day, Lordship. My
Wha-
senior counsel is not physically well.
You have informed the other side.
Lordship,
You have informed the other side.
we have tried to contact them, but they haven't received a phone. Lordship. We'll let them know.
No. You wait till your turn. We will allow your prayer. When the matter is called up, you remain present.
Okay. Right.
May I please give me note? Lordship, this is a small point, Lordship, we read with the court below, Lordship, to framing additional issues in respect of the dependency of the so-called alleged husband of the deceased, Lordship. That deceased was staying with me, Lordship. I am the mother of the deceased, and she met with the accident, and I have certain injuries. I have treated all everything, and she died subsequently, Lordship. And she is having two brothers also. But husband never lived with the
Where is the impugn order?
Supreme order is
Impugn order.
page number 26. That I have paid for framing of additional issues. But court below said that this issue has been decided. Without framing the issue, how the issue has been decided, Lords. My humble submission is that the issue may kindly frame because the MCT cases mainly depends on the dependency, Lordship. If he is dependent and well and good, he may be legally presented, but may not be dependent, Lordship.
You are insurance company.
I am for the claimant,
Claimant.
claimant mother of the deceased, Lordship. I am.
Please read the impugn order.
Yes.
Please read it.
What is Lordship?
Read in the impugn order.
This state case fixed for hearing on petition number, which is petition filed on behalf of the claimant number 1, Subala Rai, mother of the deceased, Orpana Bala Rai, claiming that the claimant number 2, Prasenjit Burman, was not the husband of the deceased, and praying for framing additional issues, that is namely whether the claimant number 2 is legally married husband of the deceased Orpana Rai, and whether the claimant number 2 is legal representative of the dependent of the deceased. Seen the petition number 1568, 2024, filed on behalf of the claimant number 1, praying for adjournment of the matter on the ground that he was unable to contact with his client. Prayer for adjournment rejected as it is for the counsel of the advance argument on petition number 856, 2024. And the presence of the claimant number 1 is not required. At the same, hence the prayer is rejected. Thirdly, learned counsel for the claimant number 2, I have meticulously gone through the records of the case, including the documents filed by the claimant number 2 at the time of praying for the impleachment of the party in the instant case. I have also considered arguments advanced by the learned counsel appearing for the claimant number 2. In the instant case, by order dated 2022, my learned predecessor has allowed the impleachment of claimant 2 as necessary party in the instant case. After hearing the submission and objection raised by both the sides and after detailed hearing on the matter, the additional issues are sought raised by the claimant number 1 by way of petition number 856, 2024, were already considered by this tribunal the time of passing the order dated 22/2/2022, and thereafter claimant number 2 was implemented as necessary party. Hence the petition number 856, 2024 is nothing but a delaying tactics on the part of the claimant number 1 to re-adjudicate the issues which have already been settled by this tribunal. Moreover, the motor accident claims tribunal is only deciding a matter whether the accident has occurred of a third party and whether he is received any compensation
for the injury or forceful force to the third parties. Motor accident claims tribunal is not a civil court to decide the legality or validity of the marriage between the parties. Motor accident claims tribunal is bound by the principles of performance of probabilities. And if the tribunal is prima facie satisfied that the person is a legal representative of the deceased, then he is bound to meet the party in the claim petition. And this court is not bound to go into the other extraneous issues. Hence, this view of the above discussion, the petition number 856 filed by the claimant is not maintainable and same is rejected as such. Let the matter be fixed for cross-examination of the witness of the claimant number 2. It also appears that
Where is the error?
the
The tribunal earlier decided an impleadment application. It was allowed on the basis that the petitioner of the impleadment application was found to be legal representative. So if they are not legal representative, you can,
They may be legally representative, but not dependent on the deceased lawsuit. So until the issues are framed, then in depth, we cannot go into that cross-examination as the lawsuit.
what are the issues which are framed?
This is the earlier order by which it was decided on. So the dependency issue was not framed, and that is a vital on the part of the MST claims lawsuit.
No,
That I-
what issues were framed? Where are the issues? What are the
That
issues?
is general issue lawsuit, whether accident took place or not, whether it is in page number 5. That is the proposed issue. These issues are not framed. My simple humble submission is that these two issues should be framed. lawsuit. And we have annexed this next of the kin certificate also. In that case, next to the kin certificate, the husband, alleged husband is not shown. Page number 25 lawsuit.
No, at what stage the MSC case is pending now?
This is pending for this evidence lawsuit. So my humble submission, if these two issues are framed, then let the proceedings should go lawsuit.
Yes,
My lord, I am for the claimant number 2 who was implicated in the case, my lord. Now this civil division petition is not maintainable. It is my first point, my lord. It is against an interim order, interlocutory order,
it is
It does
under
not-
115.
115. They have come. They have come under 115. It is again an interlocutory order which does not finally decide the issues.
Yes,
And that's how this revision petition is not maintainable. Second point is that MSC court is not empowered to decide issues of matrimonial issues, whether I'm a husband or not. It will decide whether there was an accident. Secondly, whether compensation can be granted, who will be given the compensation and in what manner. So these are my 2 points, my lord, on which I will argue.
yes. Any reply on maintainability?
This is filed under 1227 and 151 lordship.
You cannot file under both.
No, lordship. This is, since the civil matter is involved, lordship, civil proceeding. My point is, humbly, MSCT claims lies on dependency only mainly, maybe legally representative. So if the two issues are framed, lordship, then what is the harm, lordship? If they are dependents, they can be entitled for this
No,
consortium.
you have not raised the plea of dependency.
Yes, lordship, I
your-
have raised the lordship.
Your proposed issues are whether it legally married husband and wife.
Whether petition number 2 is legal representative and dependent on the district. I've raised the issue, lordship.
Heard Mr. A.R. Agarwal. You're for? Yes.
Number two, my lord. Here, my lord, the order dated 2022, which is reflected in order dated 29/6/24, my lord. My lord, that was not put to challenge, my lord, because by that order only, the respondent number one has been implemented. Now, once he is implemented, those proposed issues could not have been raised at this stage, my lord. And the learned member MSCT, my lord, could not have addressed those issues because those issues relate to, my lord, status of the disease.
No,
instead of-
otherwise also
Yes, my lord.
there will be an issue whether the claimant are entitled to get compensation.
That is what, my
In
lord.
that, they can raise the plea of dependency.
That will cover everything, my lord. But the proposed issue is, my lord, the petitioner-
Separate issue in the format which you have proposed is
because
not
the petitioner
necessary.
number one, petitioner today, my lord, is challenging the legality of the marriage of the deceased with the,
That cannot be decided.
yes, that cannot be decided, my lord.
You
because
can
the-
raise the dependency issue while deciding the main issue, whether the claimant is entitled to. You are claimant number one. Whether claimant number two is entitled to any compensation.
That may kindly be, issues may kindly be, dependency issue may kindly be allowed to be framed also. That whether claimant number one is dependent. That much only.
No. This is barred by the proviso of 115. This revision petition. Heard Mr. A.R. Agarwal, learned counsel for the petitioner. Also heard Mr. B. Prasad, learned counsel for respondent number one, as well as Mr. T. Kolita, learned counsel for respondent number two. This application under section 115 of the Code of Civil Procedure. This revision petition under section this is under 227,
Yes,
not
sir.
115.
Read with my lord, read with my lord.
That's my humble sum only that much. They may be interested for consulting.
Read with 151. Your submission is wrong submission. Not 115. This application under section under Article 227 of the Constitution of India has been filed by the applicant, by the petitioner, impugning the order dated 29/6/2024 passed by the Motor Accident Claims Tribunal, Dhubri, in MSC case number 65/2021 within bracket D, by which the prayer for framing additional issues was rejected by the learned, by the Motor Accident Claims Tribunal, Dhubri. Learned counsel for the petitioner has submitted that the petitioner has referred has filed the MSC case number 65/2021 within bracket D, seeking compensation on account of death of her daughter in a motor accident claims tribunal. He submits that death of daughter who died,
Instead of the claimant number one's daughter, my wife.
daughter. And who is claimant number two?
husband of the-
Okay. He further submits that by order dated 22/2/2022, the Motor Accident Claims Tribunal, Dhubri, allowed an application filed by the respondent number one in this case for impleading him as claimant number two in the said case, said MSC case, on the ground that he happens to be the husband of the deceased. Stop. Learned counsel for the petitioner has submitted that the husband of the deceased was not the, has submitted that the present petitioner has raised the issue of validity of the marriage of her daughter with the claimant number two, and therefore had filed an application on 21/5/2024, which was registered as petition number 865,
856,
856 or 865,
865.
865, proposing following issues. Number one, Roman number one, whether the petitioner number two is legally married husband of the deceased, whether the petitioner number two is legal representative and dependent of the deceased. He submits that as only a dependent can claim compensation in the event of death of a person on whom the said person was dependent. The issue proposed by the present petitioner were necessary to decide the
Dependency factor only. No, legal representative can claim those, but up to certain limited extent of consortium, etc.
decide the MSC case number 65/2021. He however submits that the while passing the impugn order, the Motor Accident Claims Tribunal, Dhubri, had ignored this vital aspect. Stop. He therefore submits that the impugn order dated 29/6/2024, passed by learned member Motor Accident Claims Tribunal Dhubri in MSC case number 65/2021D is liable to be set aside. On the other hand, learned counsel for the respondent number one has submitted that this revision petition is not maintainable in as much as the order impugned in this case is an interlocutory order, and therefore under proviso to section 115 of the Code of Civil Procedure, the revision is barred. He further submits that the question as to whether the claimant number two is the legal representative of the deceased has tentatively already decided by the Motor Accident Claims Tribunal by its order dated 22/2/2022, while allowing the prayer for impleadment of claimant number 2 in the said claim case. He further submits that the said order has not been impugned by the present petitioner, and therefore this revision petition is liable to be dismissed. On the other hand, Mr. T. Kolita, learned counsel for the respondent number 2 within bracket insurance company, has also made similar submissions like that of learned counsel for respondent number 1. He also submits that the order dated 22/2/2022 has not been challenged by the petitioner. He further submits that while deciding the issue as to whether the claimants are entitled to get any compensation as claimed for, the issue of dependency of the claimants would otherwise also have to be decided. And therefore, this revision petition is liable to be dismissed. I have considered the submissions made by learned counsel for both sides. Though the plea of maintainability of this revision petition has been raised by the learned counsel for the respondents on the ground that it is barred by proviso to section 115 of the Code of Civil Procedure. However, it appears that this instant revision petition has not been filed under section 115 of the CPC, but under
Article
Article 227 of the Constitution of India. Which pertains to the supervisory jurisdiction of this court over courts and tribunals subordinate to it. Stop. In the case of Shalini Shyam Shetty versus and another versus Rajendra Shankar Patil, reported in 2010 8 SCC 329, the apex court has observed that the high courts cannot, on the drop of a hat, in exercise of powers of superintendents under Article 227 of the Constitution, interfere with the orders of the tribunal or courts inferior to it. Nor can it, in exercise of this power, act as a court of appeal over the orders of court or tribunal subordinate to it. In the instant case, it appears that the order dated which order? 22/2/2022, by which the tribunal had allowed the respondent number two, that is the claimant number two, to be impleaded as a party in MSC case number 65/2021 within bracket D, has not been put to challenge. Stop. The mere fact that the the prayer for impleadment of the claimant number two was allowed itself shows that the court, the tribunal shall have to decide the question of dependency while deciding the main issue as to whether the claimant number two is entitled to get any compensation as claimed for or not. The present petitioner can raise his plea regarding his objection regarding dependency of the claimant number two over the deceased daughter of the claimant number one, can very well be raised before the tribunal, even if the issues proposed by the petitioner in the present form are not framed by the claims tribunal. It is a well-settled proposition of law that in exercise of its powers under superintendence under Article 227 of the Constitution of India, the High Court cannot interfere to correct mere errors of law or the fact or just law or fact just because another view than the one taken by tribunal is a possible view. This court is of considered opinion that no that no that this court is of considered opinion that the trial court, the tribunal had not exceeded its jurisdiction while passing the impugned judgment justifying interference by this court in the impugned order in exercise of its powers of superintendence under Article 227 of the Constitution of India. This, for the reasons and the discussions made in foregoing paragraphs, this, as well as observation made herein before, this revision petition is accordingly dismissed.
The word disposed, no, you can-
No, it has to be dismissed.
Lordship, I have a prayer, my lord. In the event of allowing the main MSC case, my lord, the interest for this instant proceeding may be waived, my lord. Interest for this instant proceeding, my lord, this petition has been filed by the claimant and there has been a stay, my lord. Case is not proceeding further. So in the event of allowing the main MSC case, my lord, interest for this period may be
No,
waived,
that
my lord.
plea you can take before the claims tribunal.
That may be observed, my lord.
No, no observation. You can take this plea before the claims tribunal.
Because
And
already we have, lordship, filed the written statement, lordship, we can at least issue, raise an issue in the stage of argument only, my lord. So that might not be accepted, if I'm not wrong, my lord.
the
Observation.
learned counsel for the insurance company has submitted that as no, that will be very contingent, very speculative. If the claim petition is dismissed, then the question of interest would not arise. So this court cannot pass any such order at this stage. You can take this plea only before the claims tribunal. There is a probability of dismissal of the claims petition, equal probability.
Lordship may can give an observation that insurance company can raise the plea of interest.
There is no bar. That observation is not necessary. Yes, stay, any stay was there
9924, my lord.
in consequence to the dismissal of this revision petition. The stay, interim stay granted earlier on the further proceeding of the MSC case stands vacated.
This matter I mentioned for extension of the interim order. Last Monday, this matter was listed, but inadvertently, though it was dictated, it was not typed. Records has been called for,
Records have not been received.
not been received. Last 27-10 order lodged will can be seen. 27-10-25, this Monday. Scan copy, scan copy of trial court record has not yet been reached, therefore registry is directed to procure the same from the Debt Recovery Tribunal. Release the matter after 3 weeks.
Lordship, in the meantime, we may be allowed to file our reply, Lordship.
Let them find.
Okay. Heard Mr. A. Das, learned counsel for the petitioner. Also heard Miss
Yes.
S. Yasmin, learned counsel for respondent number 3. On perusal of the office note dated 31-10-2025, it appears that the records from the trial courts have not yet been received. Issue fresh reminder for the same, registry to issue the reminder. Learned counsel for respondent number 3 has prayed for some time to file a written objection against the petition filed by the against the instant CRPIOP filed by the petitioner. Prayer is allowed. The respondent number 3 can do so. 3 or 2?
3, Lordship.
3 can do so before the next date. Let this case be listed after 2 weeks. The interim order passed earlier shall continue till next date.
Much obliged.
And if-
Item 4. Item number 4.
None has appeared for the appellant on call. Let this matter be listed again on in the next week on a date to be fixed by registry.
Well.
Who is for the appellant?
The last provision also there is in appeal also.
What should I do? Dismiss.
Let them give another chance.
None has appeared for the appellant on call. Mr. A. Das appears for
Sole respondent in item number 7. Yes, so the respondent 1 in item number 7
and other items.
and your lordship in item 11 for respondent 1 and 2.
In item number 7. Respondent in item number 7. 7 means LA appeal number 11/2025. Separate order hobo, common order no hobo. Government is also appearing.
But
Mm. Okay, Mr. T. R. Gogoi appears for the state respondent. No, we will not mention the number of state respondent will announce. The registry is directed to show the name of Government Advocate Assam in the cause list as engaged counsel for the state respondent henceforth. Let this matter be listed in the second week of November on a date to be fixed by registry. Item number kiman asile? 5 to 12. 5 to 12. Common order no, separate orders. Similar order.
May it please your lordship. Lordship, the learned counsel P.K. Kolita and assistant counsel Nilutpal Das. He is out of station, my lord, for medical purpose, wife of the P.K. Kolita, lordship.
Item number
13.
13.
Both are not in the position in APRB for this honorable. Kindly adjourn the matter.
What is your name?
A. Islam.
Heard Mr. A. Islam, learned counsel for the appellant, who prays for an adjournment on the ground that the engaged counsel for the appellant is out of station. Considering the submissions made by learned counsel, the prayer is allowed. Who is the engaged counsel?
P.K. Kolita and assistant counsel Andas.
Engaged counsel for the appellant, namely Mr. P.K. Kalita and Endas are out of station. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
14. May I please, Lordship? Lordship, here on the last occasion, we have taken first step upon the respondent of respondent. Lordship. However, the service report awarded. Can this matter may be listed after 4 weeks?
What is your name?
D. Rafa, I am appearing on behalf of Mr. G. Busso.
Mir
D. Rafa,
D.
D. Rafa,
D. Rabha, learned counsel, appearing on behalf of Mr.
D. Busso.
G. Bushaw, learned counsel for the appellant. On perusal of the office note, you have seen the office note. dated. Office note dated 28/2025. It appears that the notices sent to respondent number 1 has returned with postal remark refused and returned to sender. How many respondents are there?
Two respondents.
And respondent number 2?
Respondent number 2, we have already recognized.
However, as regards respondent number 2, what happened to respondent number 2? Mr. Rabha, what happened to respondent number 2?
Okay, I'm not sure, but perhaps service has already been completed.
Okay, you go through the record, we'll take it up after some time. You go through the record, find out what happened to respondent.
16.
কিন্তু গাথিহীন
Make please, your lord. Hello. The connected RFA was dismissed for default on 1/9/2017, my lord. Thereafter, I filed an application for readmission and there was a delay occasion. Service is complete, my lord.
This is condonation of delay.
Yes, condonation of delay.
We would file a reply to that. We would like to object the delay launch. Also, we have not received a copy of RFP.
Copy of?
You're for?
RFA was,
ASIDC lordship. Respondent 3 lordship.
You're for? And respondent number 1?
IOCL.
steps
Oh.
have been taken on all the respondents, my lord. Service is also complete.
Okay. Heard Mr. What is your name? D. Goswami, learned counsel for the applicant. Also heard Miss, what is D. Mahunta, appearing for respondent number 3, as well as Miss J. Tayang, appearing for J. Spelling?
CAY.
Oh, sorry, Gayan, J. Gayan. Appearing for respondent number 2. Learned counsel for respondent number 3 prays for some time to file written objection against the prayer for condonation of the delay. On the other hand, learned counsel for respondent number 2 submits that you have received the copy of IA. You have not received. Have not received the copy of the interlocutory application.
Served, my lord, your lordship,
You-
this is the earlier order. My lord, they have received notice. Notice was accepted, my lord, personally.
You furnish a copy. Learned counsel for the applicant has undertaken to furnish a copy of the interlocutory application during the course of the day. It also appears that the notice issued to respondent number 1 has also been duly served. not served. It was issued. Where is the service report on respondent number one?
Don't know one.
The office assistant has wrongly mentioned as served instead of word issued.
I did that on the.
Though the office note dated 11/6/2025 shows that the notice issued to respondent number one has been duly served. However, nothing on record could be found on the basis of which the said office note has been prepared. It appears that the office assistant has mistakenly mentioned the word served in place of the word issued. Stop. The same may be brought to the notice of the superintendent of the concerned section. What should we do? We should await, or you will take fresh steps? You serve notice on the standing
Oh,
council.
Lordship,
La-
I kindly observe
Learned counsel for the petitioner submits that as the respondent number one, that is Indian Oil Corporation, is represented in this court by a standing counsel, he may be allowed to serve the notice on the standing counsel of the respondent number one. Same is, the said prayer is allowed. Let this matter be listed after 2 weeks.
Recorded kindly. I'm appearing on behalf of Mr. S. Das, Lordship.
Please. नाम लिखिছিলেন না? So and so, what is your name?
D.
D. Mahanto, appearing on behalf of Mr. S. Das, learned counsel for respondent number 3.
Much.
deeply over.
Item 17.
Wait, please, one minute. Okay. Yeah, our name is draft of Lordship. They are pursuing the matter. Mr. A. Sattarali.
No, what is your submission?
Lordship, Mr. M. Ahmed is pursuing the matter from now. We are newly engaged earlier. Mr. M.
So,
Sir A. Sattar was engaged earlier, Lordship.
no, that is one aspect. Another aspect is you have not taken steps in spite of the court's order. So I am dismissing this case. Why have you not taken steps? Any submission? You have to make some submission. If you keep mum, heard Mr. What is your name? A.K. Kanu, learned counsel for the applicant who submits that he has been newly engaged by the applicant in this case. And he further submits that he may be allowed to take fresh steps for issuance of notice upon the opposite parties. Considering the submissions made by Lan, Wakalatnama has been filed.
Our name is deflected in police.
Considering the submissions made by learned counsel for the applicant, the prayer is allowed. The applicant shall take steps within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Our name is instructor. Mr. A. Sattar.
Learned, Mr. What is your name?
W. Hawk. W Hawk on behalf of Mr. A. Sattar.
Mr. W. Hawk, learned counsel, appearing on behalf of Mr. A. Sattar, submits that as the brief has been taken back by the applicant from Mr. A. Sattar and new set of counsel have been engaged, the name of Mr. A. Sattar may not be reflected in the cause list henceforth. The prayer is allowed registry to do the same.
As for the time being.
Okay, after some time.
I for the combination of delay of 46 days.
Your Lordship, only 46 days delay. So your Lordship may please to condone the delay. I have no objection.
Heard Mr. K.K. Bhatto, learned counsel for the applicant. Also heard Mr. D. Mondol, learned counsel for respondent number 1, 2, and 4.
All the claimant respondent, 1, 2, 3, 4.
1, 2, 3, and 4. Stop. Who is 5?
Combination of delay, let's say, we will not affect because in the appeal, we will get the notice.
Learned counsel for the respondent number 1, 2, 3, and 4 has submitted that the said respondent do not have any objection if the prayer for condoning the delay is allowed. In view of the said submission, learned counsel for the applicant submits that as the claimants are not opposing the prayer for condonation of delay, the notice to respondent number 5, who is the owner or driver,
Owner of the vehicle.
who is the owner of the vehicle involved in the accident, may be waived. Considering the submissions made by learned counsels, the notice to respondent number 5 is waived. Further, where is the grounds?
Paragraph.
Para,
3, 4, 5, 6.
need line to continue considering. This application under section 5 of the Limitation Act has been filed by the applicant insurance company Right. praying for condoning the delay of 45 days in preferring the connected MAC appeal, MAC appeal, MAC appeal,
MFA, your Lordship.
sorry, preferring the connected appeal whereby the order dated 30/11/2023 passed by the Commissioner Employees Compensation Nagaon in NEC case number 20/2022 has been impugned. Stop. Considering the fact that the opposite party responding Sabate opposite party. That opposite party number 1 to 4 have not opposed the prayer for condonation of delay, as well as considering the grounds shown by the applicant in paragraph number 5 of the instant application. This court is of considered opinion that the said grounds may be regarded as sufficient grounds which prevented the present applicant to approach this court in filing the connected MFA within the prescribed period of limitation. Hence, the delay of 40, how many days? 46 days in preferring the connected MFA is hereby condoned. The registry is directed to register the connected MFA and list the same for admission in the next week on a date to be fixed by it. This interlocutory application is accordingly disposed of.
Highly obliged.
May I please also? Joseph, here the name of the respondent number 2 has been struck off your list.
Yes.
May I produce the order dated 29/20.
Learned counsel for the petitioner appellant has also submitted that the name of the respondent number 2 has already been struck off by order dated
29/2023.
29
29/2023.
29/2023. In view of above, let this appeal be listed for admission hearing in the after 2 weeks on a date to be fixed by registry.
20. Obliged.
May I please? My lord, here in this case, my lord, substitution of legal rights of respondent number 1. And Other side has no objection, my lord. The substituting, only thing is that, my lord, I have quoted the name, my lord, at para 5 of page 9, my lord.
It is within limitation.
Yes, ma'am.
Heard, Mr. I Alam, learned counsel for the applicant slash appellant. Also heard Mr. L.R. Majumdar, learned counsel for
Defendant number, 1.
respondent number 1. This application under order 22 rule 4 of the Code of Civil Procedure 1908 has been filed by the applicant for substituting the legal heirs of respondent number 1, Shri Gangadhar Panda, alias Gangadhar Pandey, who had expired on when he died.
June, in the month of June 24, my exact date, I don't know, my lord.
Who expired in the month of June.
May 24, my lord. At para 3, my lord, I have stated.
May 24.
24, my lord.
When have you filed this application?
My lord, I have filed this application on 11/6/2024.
Okay. In the month of May 2024. He submits that this application for substituting the legal heirs of respondent number 5, respondent number 1 has been filed within the period of limitation. He further submits that where are the names?
Names at page 5, page 5, para 9, my lord. One A, 1B, 1C, Nil Bosanta Panda, Uttam Panda, Susmita Panda, and Nomita Panda.
Names of the legal heirs of respondent number 1 has been stated in paragraph number 5 of the instant application, and they may be substituted in place of respondent number 1. Learned counsel for the respondents, Mr. L.R. Majumdar, does not submits that the respondents do not have any objection to the prayer for substitution made by the present applicant slash appellant. The prayer is allowed. The registry is directed to, no, you file a,
Amended cost
uh,
title.
the names of legal heirs of respondent number one as mentioned in paragraph number 5 of the instant application are allowed to be substituted in place of the deceased respondent number one. The appellant, how many appellants are there? The appellants are directed to
One appellant.
yes, the appellant is directed to submit the amended cause title of the memo of appeal within
1 week, my lord.
within 1 week from the date of this order.
Since my learned friend has informed me that one of the name one A and one D and E, he has informed me, my lord.
There is some defect lordship that may be
I have
corrected.
corrected the and amended the same, submitted to the registry. my lord.
Name is wrong.
But in fact, my lord, he told me that he has also Neil Bosanto and Sushmita Panda and Nomita Panda, he has some doubts, my lord. So he will collect the information and inform me, my lord. Accordingly, I
Now, whose name will be
Madam?
substituted?
Lordship, there are in the lordship substitution petition 5 name, but there is a defect in the name of the one lordship, 1A. And also lordship 1D and the 1E are the one and the same person.
Then you have to first verify and then correct your this application. Then only substitution petition can be allowed. Otherwise, wrong person will be substituted.
In that case, my lord,
Or otherwise, you have to again file an amendment application.
my lord,
Because-
in that case, I may be allowed to file an additional affidavit with corrected name, my lord.
Yes,
It
Cut
will,
off.
it will be proper.
or pura cut. Learned counsel for the applicant submits that as there has been some typographical error in mentioning the names of the legal heirs of the deceased respondent in paragraph number 5 of this instant application, comma, he may be allowed to file an additional affidavit mentioning the correct names of the legal heirs of respondent number one.
It should be submitted by my partner.
Stop. Learned counsel for respondent, Mr. L.R. Majumdar agrees to furnish the correct names of the legal heirs of respondent number one to the learned counsel for the applicant within a period of 1 week from the date of this order. List this matter again after 2 weeks.
Like
My lord, I have another mistake, my lord, for renovation of my house, my lord, at 2055 of 24, my lord,
In this case,
2055.
actually it is not maintainable. The suit for lordship for
I may
recovery
be-
of possession,
I
but
may
they
be-
have filed a in the line of both the courts below, they are the defeated parties. But they filed a application for renovation of the house in the suit premises.
My lord, I may be allowed to.
no, just a minute. Whether RSA has been admitted,
Statement.
stay has been granted. You are possessing the suit property.
That's why.
It is in dilapidated condition.
That, my lord, I have annexed the photo.
You
of-
file a written objection if you want. Let him file. In IA number 2055. Heard Mr. I. Alam, learned counsel for the applicant. Also heard Mr. L.R. Majumdar, learned counsel for the respondents. This interlocutory application has been filed by the applicant slash appellant in connection with RSA number 128/2023, praying for what is the prayer?
That is the page 12, my lord.
Praying for leave of this court to renovate the old dilapidated Assam type house situated over the suit. Suit property is the land,
Lordship,
land or the house
land and house both. Lordship.
situated over the suit property. Stop, learned. Counsel for respondent, Mr. L.R. Majumdar, objected to the said prayer and submitted that he may be allowed to file written objection against the said prayer. The prayer is allowed. Let this matter be listed after 2 weeks, along with the main RSA number 128/2020.
My lord, this delay for 62 days they have given, but we have objection because the reason for 62 delay is not been given by the council, opposite council, as well as this, as the statement made in paragraph 2, it's a matter of record. Because no document in support of
Will
this.
you be filing any written objection?
Yes, my lord, we have already filed.
You have filed? Okay. Yes, then let the applicant submit first.
Yes, but the written documents that my is referred to pertains to some mails between the officer party. Are we allowed to produce them like that? I'm telling you. Because 62 days, I did not think this. I'll try to explain 62 days here. I think some mails were exchanged between the office, branch office and the head of. That is.
You want to file additional affidavit?
That is the only requirement. Otherwise, it's a, I'll try to explain now. If your lordship is satisfied.
Also, in
otherwise-
paragraph 3, there is no question or there is no
Okay.
substantial question of law. So in this
Substantial question of
matter,
law is
appeal-
there.
appeal
I
is
filed the
valuable.
substantial question. Along
No,
with the
no,
memo.
now this interlocutory application is on the question of
Only
delay.
question, delay on.
Delay. You file an additional affidavit, let them file.
Lordship,
We'll,
yes, I'll try to explain. I'll
we'll
file
hear
it.
you.
Lordship and my learned is not
Heard
satisfied.
Mr. R. Goswami, learned counsel for the applicant. Also heard Miss, what is your name?
In behalf of,
What is your name? Heard Miss A. Roy, learned counsel for the respondent. Who? Respondent number? You are also appearing. Respondent number 2, as well as Miss R. Bhargav, appearing for respondent number 1. Learned counsel for respondent number 1 objected to the condonation of delay of 62 days in preferring the connected appeal by the applicant, as the delay of 62 days has not been properly explained by the applicant. On this, learned counsel for the applicant seeks leave of this court for filing an additional affidavit to bring on record certain documents which are relevant for consideration of the instant interlocutory application. The prayer is allowed. How much time? Let this matter be listed after 2 weeks.
Item 22.
If I may, my lord, the IA for injunction,
injunction restraining the opposite parties over schedule D land, my lord. Since last year, my lord, they've been,
Restraining the opposite party from
further constructing over schedule D land,
Schedule A land,
D land.
D.
Yes, my lord, the opposite party persons have appeared, my lord,
1 to 7, 8, 9, 10 is struck off. What if we may allow to file objection affidavit for 2 weeks,
Written objection.
written objection?
yes,
Let them file.
yes, my lord. My lord, in the interim, my lord, if an order is passed, because since last year they've been constructing, my lord, my only anxiety is, my lord, since they've been constructing since last year, my lord, it may later on pose problems for us.
Since last year.
Yes, my lord, since, my lord, 22/10/2024.
So what is the urgency? If they are constructing since last year. Interim is granted only in case of urgency.
Yes,
Let them file, we will fix a short date.
yes,
Heard Mr. G. Imtiaz, learned counsel for the applicants. Also heard Miss
P. Bordula.
P. Bordole, learned counsel for the respondents. Who for respondent number
1 to 7.
1 to 7. One to 7. Who submits that the said respondent intends to file a written objection against the prayer for temporary injunction made by the applicant, and some time may be granted for filing the same. The prayer is allowed. Let this matter be listed after 2 weeks. Only date to be
Friday,
fixed.
my lord. Any date, my lord.
In the 3rd week of November, on a date to be fixed by registry.
My lord, on
No, registry will fix the date. I am fixing the week.
weekday of that.
Next, matter may be come up next week, madam. They have not, that's why my,
You have prayed for, who has prayed for adjournment?
he, my lord,
What is your name? Who is for the,
I'm for the applicant, my lord. And my learned friend in the morning, my lord.
heard Mr. Yes, okay. Heard Mr. I. Alam, learned counsel for the applicant / appellant. Also heard Mr.
PB Kakoti for the sole respondent.
B.B. Kakoti, appearing for the respondent. Learned counsel for the applicant prays for an adjournment on the ground of personal difficulty, to which learned counsel for the respondent raises no objection. Hence, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
Oblige. 24.
May I please, your lordship? Lordship, as per the office note data 15/5/25, lordship, we have taken steps, lordship. And lordship, the steps may be presumed to be served, lordship. And lordship.
Why such presumption may be taken?
Though the AD is not been received yet.
When have you taken steps?
On 15/5/25, lordship.
15/5. We'll ask the registry to place the track consignment report, postal track consignment.
And also, lordship, we have taken dusty service against the respondent number 2, lordship. The receiving copy is supposed to be there in the record, lordship.
You have served it.
Yes, sir.
You file an affidavit. Heard Mr.
A Brahman.
A. Brahma, learned counsel for the petitioner. This is review of what?
Of make appeal, lordship.
On perusal of the office note dated 18/6/2025, it appears that the notices issued to respondent number 1 and 2 by registered post with AD has not yet returned. Stop. Registry is directed to place the track consignment report, postal track consignment report of the notices sent to respondent number 1 and 2 through registered post with AD. Learned counsel for the petitioner further submits that the notice upon respondent number 2 has been served by Dusty Mode. You have served it.
We have served the copy of the this review petition to the Angus Council, not directly to the respondent number 2.
No, you have to. Council has not appeared. Serve the notice through Dusty Mode on the engaged council of respondent number 2. It is a review petition. Who is respondent number 2?
Cholamandalam, General Insurance Law.
Learned council may submit an affidavit in compliance of the notice served on the council of respondent number 2 through Dusty Mode on the next date fixed. Let this matter be listed in the second week of November on a date to be fixed by registry.
God bless you.
None has appeared for the applicant on call. Let this matter be listed after 2 weeks on a date to be fixed by registry.